Where the secrets grow, names on the list only the shadows know. Files stacked high like a tumbleweed roll. Arizona, DCS and Central Registry Data Base, where the truth hides in a dusty old case. Spin that wheel, but it's never your place. It's a game of hide and seek in this space. Paper trails longer than a rattlesnake's tail. Stories locked up like a ghost town jail. Who's got the key to this endless trail? Oh, they shuffle the cards and deal out scars. Arizona, DCS, Central Registry Data Base.
This meeting is being recorded and or transcribed. Thank you all for coming. If you could please mute yourself at the moment, just so we can make sure we don't get kind of any edits with the recording. This is the public meeting for the DCS rulemaking, Title 21, Chapter 1, Article 5, Substantiation of Reports, also referred to as the Tiered Registry rulemaking. My name is Nicole Freeze. I'm the General Counsel of DCS. With me today are Melissa Copian, the Manager for our Policy Unit, who supervises our rulemaking team, as well as Karen Wooters, our Agency Rule Writer, and Selena Moreno, the Manager for the PSRT Unit. We are here to receive any comments or questions that you have about the rulemaking that was published in the Arizona, Administrative Register on September 12th of 2025. There are quite a few changes, and so we're not going to summarize all of them here, but if you are not familiar with the changes that are being made in the rulemaking, please go ahead and look at that copy of the register to see those changes. We will accept verbal comments and questions during this hearing. We also will accept written comments till 5 p.m. today when the public comment period closes. DCS will then take your comments and questions and feedback and draft the final rulemaking and request approval to continue the rulemaking from the governor's office and then proceed to submit it to the governor's regulatory review committee, council, where you can also watch those proceedings and see it move forward. At this time, we'll open it up to comments. I think since we have a number of folks on the phone, I'm just going to ask for different people to speak. If you are just here to observe, please just introduce yourself on the record, and then we can go to the next person. But since it's recorded, please introduce yourself. Okay. I will hand it over to Isabella first, just to introduce herself.
Hi, good morning. Isabella Levitt. I am just observing today, so I have no public comment. Thank you.
Marcus?
Good morning, everyone. Marcus Reisinger. I'm an attorney in private practice at Woodnick Law PLLC. I am here to observe, and we'll just be entering a written comment.
Okay, thank you. The number that ends in 2298.
Good morning. My name is Lori Ford, and I'm with the AZ DCS Oversight Group. So far, I'm just observing today. Thank you.
And the number that ends in 5055. There's only one other person on, so if you haven't spoken yet, you're up. Okay. Well, they might have muted themselves. If you want to call back in, because we listed in the register that we would be holding this public meeting from 10 to noon, We will hold it open, so if others join, they'll be able to leave a comment. We will also provide a full list of any public comments provided either verbally or in writing to the agency in our notice of final rulemaking. So if you are observing and you don't want to just wait to see if anyone else attends, you will be able to see the other comments in that location. I think at this time we can just sort of take a break to see if we have anyone else join, or if our mystery caller wants to speak up. Otherwise, I don't think at the moment we have anyone else in the lobby, and so we don't have any comments at this time.
Can I just ask a quick question?
Of course.
Once the comment period closes, what's the expected timeline for the final rules to be published?
Karen or Melissa, how many written comments have we received so far?
I have not received any.
Okay. So other than your potentially forthcoming one, Marcus, I think we expect for the time period to be pretty short because we want to try to stay on the timeline that we anticipated, since this rulemaking is a result of the legislative change. So our goal is to get the notice of final rulemaking unless we get any comments that mean we have to substantively change the rule, which is hopefully not the case at this time. I think our intention is to submit a request to the governor's office to proceed with the rulemaking tomorrow, and then we will hopefully submit it to GERC at the next deadline, which I believe is next Tuesday, which would mean that in about technically 6 weeks' time, it would be on the GERC agenda. And so we are hoping to proceed with this rulemaking so that it's effective by December.
That was going to be my next question, is when they'd be effective, so thank you.
Oh, I heard our caller come off mute. Would you like to introduce yourself or make a comment?
Yes, hi, I'm Allison with Arizona Normal.
Okay.
Allison Stein, Arizona Normal. We have a few comments. Let me get my notes up. We would like to thank you for prenatal exposure and never having it placed on the Central Registry, but we do have concerns about removing people for prenatal exposure, substance abuse exposure. For that, we were instrumental in the Rogel versus DCS case. And we also have questions about due process deficiencies. The rules as drafted give discretion to the department to deny challenges to placement. There's no clear avenue on independent review. This raises serious due process concerns. At minimum, the regulation should provide notice of the evidence relied upon, opportunity to be heard before a neutral decision maker, and a judicial review, a right of judicial review. I believe we sent in our list, but also one of the things that got to me was all the prenatal exposure statute, like the criminal statute, and to remove people from the Central Registry, you're saying it's Schedule 1. You're using the schedule, so I would like you to cite state law, because there's issues there. And yeah, that's about it. Sorry.
No, don't apologize. Melissa, what makes the most sense to have her resend just to make sure that we captured their written comments? And she mentioned that they had already sent them in.
Okay, awesome.
Sorry, it was Allison, correct?
Yes.
Allison, did you send those via email?
I'm not sure, Julie. would have said that, and I can circle back to her and make sure.
Okay, I can also receive those at DCS rulemaking at azdcs.gov. Selena, were there any of the comments that you wanted to reply to at this time, or would you rather that we reply to all of them in writing?
I did have a clarification question. When you first began, you talked about how you were satisfied with somebody not going on the registry for the SCNs, but was not for the removal of them.
Right.
I didn't quite understand that. Can you clarify that a bit more? It's my understanding that you're not placing people on the Central Registry while pregnant, but that it's going to be harder for them to get removed. The ones that are already on there, transfer them to get removed.
So, Selena, can you explain how it changes now, like with the legislative change, how it will affect those who are already on for the same elements?
Yes. Okay, thank you for clarifying. So you are correct. The SENs is the 0 years on the registry. So for those that are already on the registry, we have to conform those per the statute. So next year, the date is May 2026, where we have to basically go in and all of those people that are already on the registry, we have to go ahead and then remove them or place them on the applicable tier that goes into effect. So those that are on there for SEN exposures, we would go in and remove them at that later date. We're just right now making it into effect for the current substantiation. Does that
Okay.
I have a follow-up to that? Yeah.
Sure.
What about not being able to get sober in a certain amount of time? Just allegation, and how are we going to remove people from things from the country?
Allison, it's a little bit choppy, but I think your question relates to if they're substantiated for multiple allegations, how they would move essentially based on those. So Selena, I don't know if my understanding is the longest or most severe tier would be the one that they would be placed with for the substantiation. So they wouldn't come off the tier, or they wouldn't come off the registry until the amount of time for whatever the most severe allegation or the highest length of time that we were able to substantiate them for and was upheld if they appeal. That would be the tier that they're placed at.
That is correct.
Okay,
that makes sense. Thank you.
I think that's all we have, and I'll make sure to email those over.
Okay.
I mean, we have this, but yeah. Thank you. Of course. And then we had someone join with a 3623 phone number ending in 3623. Can you please introduce yourself for the record, and then if you do have a comment or question, please feel free.
Yes, my name is Samantha Cooley, and I have no comment or question at this moment.
Okay.
This is Lori Ford. I do have a question or two.
Okay.
Okay, so the registry is, are you saying that to get people off the registry, it will be retroactive?
I think the answer is sort of, and I'll have Selena tell me if I'm explaining this wrong, but essentially, for all those currently on the registry, as of next May, DCS must conform where they sit
in their period of substantiation with the new rules. So right now, everyone who's substantiated goes on the registry for the same amount of time. But with all the different allegations, the legislative change and then this rulemaking says they should be on for different amounts of time. So DCS will be looking at essentially time served on the registry, and if they either have done the full amount of time for the tier of the allegation substantiated against them, or it's a 0 years tier, DCS will remove them, and we will provide notice that they're being removed. For those individuals who have not yet filled the full time, and there is still a group of allegations that once substantiated, you still have to serve 25 years. Like, there will still be individuals that will remain on the registry despite being on it for a number of years, because they have not yet filled the full amount of time for the allegations substantiated against them. But DCS will put them in the correct sort of bucket and track that so that when they have finished the time for their tier, they will be also notified they're being removed. So those are all options. And then also in this rulemaking, there is a function for individuals to apply to DCS to be removed early. So regardless of the amount of time associated with the allegation substantiated against you, you can also say, I think these are reasons that I should be removed early despite the substantiated findings.
Okay, so we're going to be at the mercy of DCS and their substantiations in spite of their non-disclosure issues in court. Is that what I'm hearing?
So I think I would say it a little bit differently. Currently, DCS staff are who substantiate any of the findings that the individuals on the registry have against them. Someone in DCS is who identifies the allegations that might meet the requirements of being placed on the registry, and then it comes to the PSRT unit that reports in DCS. They look at it, they see if there is evidence to support that, and then they will, and I'll hand this to Selena to probably explain better, but they will then provide that information to the individual saying, these are the allegations against you, this is what we have found that supports it, and we believe this should be substantiated. And then that individual currently, this is already the case, can reply and say, let's say, that's not me, that's factually untrue, here's the evidence I have to refute it. They can also appeal it. So that goes in front of an administrative law judge. Again, this is the current process, who, there's a hearing, they can call witnesses, both the department and the individual can call witnesses, they can choose to be represented. There's opportunities for further fact-finding or evidence to be brought out if an individual feels like that's not true and shouldn't be substantiated. And then the judge makes the determination, and the individual, if the judge determines that it's substantiated, then they'll be placed on the registry. So that's the current process.
Right. The
changes in the rulemaking are going to allow for people to not be on the registry as long, if at all, depending on what those allegations are.
Right. So all around, parents are still at the mercy of DCS when it comes to being on the registry.
Yes.
Okay. The teams making the determinations are not changing.
Right.
And Lori, just to clarify, because I heard you throw in non-disclosure, because there's two different types of findings, right? There's people that are going through the juvenile court process because of allegations, and there's a superior court judge that makes findings and adjudications. Those people go on the registry as well.
Right.
And then the process that Nicole just explained is the non-dependency findings. So they're getting their due process they're getting their due process somewhere. So to the effect that it is at the mercy of DCS, it is because we're operating it, but they're being heard by judges or they're getting their due process. If the Superior Court judge makes a finding of abuse or neglect, then that's the decision that our team, PSRT, reviews and places somebody on the registry. So we don't have any say when a judge makes a finding of abuse or neglect. So I would say those ones are a little bit different than what Nicole just explained to you.
Okay. What I was referring to with the non-disclosure is the convenings and the court hearings at the Court of Appeals Division 1 were holding with DCS in regards to mainly the exculpatory evidence not being brought up in the DCS courts. And it's, their guardian system just didn't have the capabilities or whatever. And so there's exculpatory evidence that is not getting into the courtrooms. So DCS
I'm concerned that with that due process decision by the judge that they wouldn't have the full information when making it.
They're not getting the full information, exactly.
Yeah, so DCS, as you mentioned with the Court of Appeals, DCS has been ordered to make sure that is not happening anymore and has thrown any resources we had as well as made sure to prioritize any court requests. So they are automatically, the front of the line so that is not happening.
And is that including emails and text messages between?
Yes.
Okay. So that's all handled now?
Yes.
Okay. Okay. Thank you.
Of course.
Thank you, Lori, for clarifying.
Sure.
And then I will just say it again because I know you asked Marcus, but I sort of only answered partially. The timeline that we are currently looking at, barring, again, any comments we received today or in writing that we feel like the rulemaking needs to substantively change, our goal is to be able to submit to GERC so that it would be heard and hopefully approved by GERC to be effective December 2nd. We are requesting an immediate effective date since it is complying with the statutory requirements in the session bill, but also because, again, in some instances this is retroactive, but in all instances we obviously want to give individuals on the registry the best possible outcome and timeline. So we didn't want any delay and did everything we could to make it as effective as quickly as possible while operationalizing it. So that's the goal. I think we should still be able to meet it, but we will obviously publish anything both in the registry and on our website. If a substantive change is necessary, then supplemental rulemaking would be published.
Sounds great. I was hoping it would be effective as soon as possible, so I appreciate it.
Yeah. Okay. Well, we may have other people join. If anyone on the call has other questions or comments, please feel free to raise them. I will leave this meeting in the capable hands of our other DCS team members, but it will be open till noon in case anyone does have questions or comments. And as I mentioned, you can submit them in writing as well to that email, dcsrulemaking@azdcs.gov, until 5 p.m. today when the comment period closes. Thank you for joining us.
Are you all going to be on here for like about 5 more minutes?
It was a little hard to hear you. Were you asking how much longer we'll keep this open? We plan to just hang out on standby until noon.
Okay.
So you're welcome to hang out as well, or submit, written comments to our DCS rulemaking inbox.
Okay, thank you.
Thank you.
Hi, this is Lori Ford again. I just want to get the email address. It's dcsrulemaking@dcs.gov.
At azdcs.gov.
At azdcs.gov.
Yes.
Okay, thanks.
Thank you.
Hi, this is Lori Ford again. I have a question for you.
Sure, Lori.
Okay, so I know that in the past, it would go before the administrative judge, and then the director could overturn that judge. So, for example, if a judge says, no, you don't need to, you're not going to be on the registry, the director can come in and say, oh, yes, you are. I know that happened with Philip B. and some other cases. Is that going to be the case still, or did the Chevron doctrine disappearance have an effect on this?
Selena, you can correct me if I'm wrong, but this rulemaking still addresses that piece as well. So there would still be that process that you talked about, Lori, about the director being able to overturn the administrative law judge's recommended decision, but there's additional guardrails in place that this rulemaking contemplates.
Okay.
That is correct.
Okay. So the Chevron doctrine disappearance has nothing to do with this? Am I hearing you right?
I'm not really sure, Melissa, what that part is referring to. Yeah, Lori, I apologize. I'm not familiar with the Chevron doctrine that you're discussing.
Marcus, you know.
Yeah, the Chevron doctrine was a federal law issue. So it basically said that courts needed to defer to agencies' interpretations of the law as long as they were reasonable, but that didn't ever apply on the state level in Arizona. Arizona did away with Chevron deference by statute in 2018. That's ARS section 12910F. And so the courts don't follow Chevron in Arizona and haven't for a very long time. So the Supreme Court abandoning Chevron in the Wilbur Bright case last year doesn't affect state rulemaking or state agency actions.
Thank you for that answer.
Thank you, Marcus.
Can I get that again at 12-910F?
That's correct.
Okay. All right. Thank you very much.
You're welcome. I've had a whale of a time teaching my students not to use Chevron anymore because it was so ubiquitous for so long.
Right.
Nobody seems to understand that it's just gone now.
Yeah. Yeah. This is Lori Ford again. So come May of 2026, that after May of 2026 is when parents should be expecting letters from DCS. Do I have that right?
Hi, Lori. So the statute requires DCS to conform all of those entries by May 15th, 2026. Selena, I'm not sure if you can speak to how we plan to operationalize that.
Yes, after May of 2026.
Yes. So they will be receiving some type of notification as quickly as possible, obviously, with the amount that we're going to be working with. We will be trying to send those out as quickly as possible with that turnaround time that we have.
Okay. Just so I can...
I anticipate some addresses are going to be changed, right?
Right.
So that's something that we definitely have in mind. I don't know that there's a way that we can really address that unless people, contacting us and letting us know they've had a different address. Or we do get calls, from the public from time to time that people have been on the registry for some time, right? And they're trying to gain employment. They're looking for notifications. So I believe that people that this is really affecting or that really want to know if they're on or off the registry, there are avenues that they can contact us.
Okay. I would somehow like to help with that. If you can give me a contact, either email, phone number, something, so that I can get parents to contact DCS with new addresses. Is that possible?
Sure. Sure. Yeah. Because it's a little ways out. We're still developing the process of it, but there may be something that maybe we have, and I don't know, this is just me thinking, a specific line for that. I don't know yet. But I can tell you right now, we do have a PSRT email address that is our general email box that you can have right now. And we can even start doing those updates now through that email address.
Okay, what is the email?
It's just PSRT.
PSRT@AZ.
Mm-hmm. DCS.gov.
DCS.gov. Okay. All right, I'll start putting the word out there.
Thank you.
Sure. Thank you.
Morning.
Hey there, how's it going?
Good, how are you?
Just peachy, thanks for asking.
Good morning, Julie. We have already had a few people on the line introduce themselves and give public comment if they do have it, and we're just holding the line open until 12 to make sure that we receive comments.
Magnificent. May I make a comment too?
Yes.
Excellent. And I'm working from home, so I hope the dogs don't want to comment. But first, I really thank you for your work on this issue. I have some questions more than comments about the draft rules. In particular, I was very pleased to see that this idea of in utero or prenatal child neglect will no longer be cause to place someone on the registry. I am concerned that the way that the rules have been drafted, especially when you reference Schedule 1 or Schedule 2 substances and use the word child, which now under Arizona law means a fertilized egg at any length of gestation, that those two inclusions would still be used to place people on the registry for prenatal child neglect. So I'm wondering if it's a drafting error or if that's the intention, because it seems to me that those exceptions are so big that they end up dwarfing the rest of the rule, and I see that as an opportunity for some clarity. I also worry that with respect to, I think you've done an admirable job about retrospective relief and placing people into tiers so that they could potentially be removed automatically. We know that that is the gold standard when it comes to restorative justice, because when you place, when you make it so that people need an attorney to do this kind of work, you place that relief beyond the reach of so many. But the one area where it doesn't appear that there's retroactive relief is in that category of conditions for which one would never be placed on the Central Neglect Registry. It seems to me that the way it's written is going forward, people wouldn't be placed there. But what do you do about all of those folks that have been placed there at this point in time, and how are they applied to relief? My last question is actually about overlapping categories of neglect. A lot of the cases that I see potentially start with, let's say, cannabis use during pregnancy with or without a medical marijuana card, but then are transformed into investigations that are more related to conditions of the home or poverty-related factors. And what I don't understand from the rules is how a case that potentially has different bases for abuse and neglect would be treated under these rules. Would it be under the highest possible status? Is it a mix? It would be really helpful to have clarity on how those cases are going to be treated. And then last, I do like in the rules that there's the opportunity to hear feedback from the department, like here's why you're not eligible at this time. It seems to me that having more due process around those issues could really be helpful, for that people understand before they apply what category they're going to be placed in, and B, what happens if there's a discrepancy between what the parents believe and what the department believes, and how are those adjudicated? Because it seems right now that there's no due process relief for people who have been denied and they believe to be denied unfairly. We're also reducing these comments down to writing, if that is at all helpful, but I really appreciate you all going through this process, and I'm curious how much of a give and take this is, if this is me asking you questions and you potentially having answers, or if you're just capturing all of these for the next draft and eventually there'll be some comments.
Julie, thank you. That would be helpful to also receive those in writing so we can also issue our response in writing, but I think some of these we should be able to answer. I kind of took down notes, so please let us know if we didn't capture anything, but the overlapping categories of abuse or neglect. Selena answered that one a little while ago, so Selena, correct me if I'm wrong, but the person would be placed on the registry based on the tier where the highest tier that the allegation of abuse or neglect was captured in.
Yes, that's correct.
And then you discussed the retroactive release. So the statute requires by May 15th, 2026 that the department conform all of the entries that are in the Central Registry currently. So those will be recategorized in the new tier system that these rules are contemplating by that date. And then we discussed earlier sending notice to individuals who are already on the registry once the conforming process is done, to let them know that either they're no longer on the registry because the allegation of abuse or neglect now falls under the 0 category tiers, or they've already served the time on the registry based on these new tiers, so they're no longer on the registry. Those ones that are already, 25 years might still be on the registry, just depending on the time that has already been served.
That's really helpful. So what I heard you say is that for that category that should never be on the registry, even though it lacks, I think, the same wording that the other tiers do, those folks will be automatically removed come May 15th and could petition to be removed even earlier once the rules are finalized.
Selena, correct me if I'm wrong. I don't know about that second piece, like if they would be able to be removed as soon as these rules are finalized. But it's the department's intent to conform all of those entries by that May 2026 date so that those folks are removed. Did I capture that?
Yes, you did. Wait, can I ask a follow-up question? This is so helpful, you all. Thank you so much. What does the data keeping look like right now at DCS? For example, if somebody filed, I forget what it is it a 2040, to get their entry on the Central Neglect Registry, would it tell them what category they fall into? Or is this someone at DCS looking at the case file from however many years ago and then making that determination of where they fall? Does that question make sense? I can rephrase it too. In the criminal law setting, it's super easy, right? Like, you can see the statute that they're charged under, and oftentimes when it comes to retroactive relief, like, you can see which categories that section of law applies to. Is that the way records are kept? And how does somebody know
So for the tiered registry, if they were to receive a check from the registry, if it's going to show what tier they're on?
Yeah, I think that's my question. Because, and here's the context for the question. So in working through Lindsay Ridgell's case, the mama who had a medical card and was attempted to be placed on the registry, when she was going through the ALJ process, it seemed like the basis for her being placed on the registry changed as different arguments fell. So it started with, this is prenatal child neglect for consuming a scheduled substance. But when it went to appeal, the department claimed no, that the additional basis of neglect is not telling your doctor all of the substances that you're taking. And that doesn't fit squarely into your tiers. So I'm wondering if there's a place that people can go. So, I mean, because we know that people will have changed residences between being placed on the registry. And so a lot of those notices aren't going to be effective. And even if they are, will that notice say it is because your case was this? And if they disagree on the category, is there a mechanism to have a conversation about it?
So lots of questions to answer in one. So I think going back to that question about the applicable tier that they're on and saying like this is why you're being removed or this is why, I think that's the goal, is that we have something saying you fell under this tier, that's why. In today's current checks, since we don't have tiers, I believe when they receive a check, it does just say abuse or neglect. It doesn't have the actual description. So you are correct about that. For the Ridgell matter, it's been a while, so I don't remember quite about the facts.
I don't have to directly respond on the Ridgell matter, but the point is still the same.
Yeah, generally speaking, in that situation, it should have just been a substance-exposed newborn finding. It shouldn't have changed into, like, an actual different type of, say in our system we have different descriptions, right? It shouldn't have changed into something else. I think maybe it was evidence-based, I'm not sure, but it shouldn't do that, is what I'm saying. So future state, when we're conforming it and we're removing from the individuals from that, we should be able to say why it's this. Now, as far as opening dialogue when they disagree, that is not built into the rules as far as like a disagreement for the removals. It's just a department decision. Although there's not something written in the rule for that, there are definitely discussions. So I manage the team that oversees the substantiations in the registry. So we do have those conversations with individuals in this current climate today about things. So, I mean, there are ways and opportunities to discuss it. But when we're removing or even for the early application, we're planning to be super specific as to the reasons why in our letter. That kind of answers it, but I think it's something we're still filtering out what we currently do versus what we'll continue to do at that time, and then what we'll add in place of certain things that we do now as well. All that to say, we're working on it still too, because the conforming, like we're trying to get this part done right, and the conforming part's like our next tackle.
I do not envy the project that you have in front of you. I know that this is a gargantuan task that is fraught with all sorts of minefields. One last question, since this is so super productive. I am wondering if it is the intent of, hang on one second, if it is your intent that all substance exposure cases will not be placed on the Central Neglect Registry, or if it is your intent that if it is a substance exposure due to Schedule 1 or Schedule 2, which are listed in some of these tiers, for example, C2, a positive toxicology of the child, if the intention is that exception dwarfs the general rule, no placement for substance exposure.
I'm actually glad you brought that up again, because you did bring up Schedule 1 before, and someone else commented on this before you got on. That is not the intent. So that is something that I think someone else clarified as well. Those substance exposed newborns will not go on the registry in its totally in its totality. But the Schedule 1, I think we need to clarify a bit. I think the previous person that brought that comment up was saying to make it more like state statute or criminal state statute versus the scheduled. The scheduled ones are going to be those situations where an individual or a parent gives a child drugs specifically, right, that weren't prescribed to them or things like that. So that's what that intent is. So it is, I see the confusion, so that is something we're taking back as far as comment.
Beautiful. Okay, so a child does not mean a fetus in utero for the purpose of subsection B and C of that. Amazing. Y'all did great work. Thank you. I'll go post something nice now on social media. I appreciate y'all.
Thank you. Thank you for your comment.
Bye, Julie.
Bye.
This is Lori Ford again, and I'm coming from, parent and public sentiment about the distrust with DCS. Is there any outside or different agencies that could be handling this besides DCS?
Lori, I appreciate you expressing that sentiment. The statute specifically leaves DCS up to managing this process. Yeah, so that's where we came from with drafting the rules.
Gotcha. Okay.
Just a quick comment to add on to that. So there's federal legislation from, I think, the mid-70s called CAPTA, Child Abuse Prevention and Treatment Act. And that statute required the states, in order to obtain grant funding, to maintain a central registry of substantiated abuse and neglect cases. But generally speaking, the federal statute leaves it to the states individually to decide how they're going to implement their own registry. And Arizona's legislature has assigned that responsibility to the Department of Child Safety. So that's the sort of legal underpinning of why DCS is the agency responsible for the registry and why that registry exists. So I hope that helps answer your question a bit more, Lori.
Yeah, it does. Unfortunately.
Thank you, Marcus.
Unfortunately. All right. I just got another idea for a new bill. So thanks for that, Marcus.
We just had an additional person that has joined. I did not recognize your name. I believe it's pronounced Ashisha. Would you like to introduce yourself and leave a public comment? Okay, thank you. I thought so. Thanks, Jason. I recognized your name.
This is Lori Ford again. I have another question. I have parents asking how they can find out if they are on the registry. So what I normally tell them is if you've had a DCS case, you're probably on the registry. So am I wrong in telling them that?
I can answer that. I would say yes, Lori. Just because there's a DCS case, there's many people that are not on the registry even though they've had a DCS case or report or anything.
Okay.
If they want to know if they're on the registry, there is a way for them to get a check. They can request an individual check themselves through our DCS website. There's a form for them to fill out. That's actually that's a different team than our team. than the PSRT team, but there is a Central Registry team that runs checks specifically for individuals and for people trying to obtain employment or just individuals wanting to know if they're on the registry for themselves.
Okay.
There's a form. If you go to our form on our website, under resources, there's an option to search DCS forms.
Okay.
And if they put in Central Registry, there is a form that says individual Central Registry request.
Okay.
And I would suggest they fill that out if they're unsure. I think when you tell them if you had a DCS case and, you know, there was court involvement with Superior Court, you know, the dependency process, maybe those times are the more accurate times to say you might be on the registry.
Yeah, that's
but again, that's still not a for sure thing.
Yeah, that's when they usually ask, is after they've been in court and, you know, they maybe a lot of times they don't get the letter saying, you know, you've been put on the registry and you have, what is it, like 2 weeks to appeal it or something. A lot of times they're not receiving that letter. So my first...
Well, in those cases, sorry, I do want to clarify. In those cases, they're not going to receive a letter from PSRT. The dependency matters, they're receiving notice to the dependency petition, and those would be discussions with their attorney, however they decide to go forward with that dependency matter. So PSRT is not involved in sending letters or notifications. We only send notifications for the non-dependency matters. Because they're not, the dependency matters, their due process is through the juvenile court. They wouldn't get due process through the administrative court.
Right. Yeah. Okay, so
Okay.
It's usually after they've, you know, been involved in the DCS court process for, you know, months, and then they'll say, hey, you know, how do I find out if I'm on the registry? So the website and the form information that you gave me is good information that I will pass on.
Okay. Awesome.
But I know at one point, parents were getting letters saying you have been put on the registry.
When there's a close of an investigation, the investigator will send a closure letter saying its findings were proposed, obviously with services letters. So they are getting that letter from the investigations team. Back in the day, though, PSRT, the Protective Services Review Team, used to send letters on the dependency matters as well, just advising them this is your due process through the JD matter. That stopped in 2017.
Yeah. Okay. Yeah.
So that might be what you're referring to.
I was referring to the actual, you know, letter that says you're put on the registry and you have 2 weeks to appeal it.
Okay.
Yeah. This is Lori Ford again. I have another question. I'm just wondering if there is allegations against a foster contractor or a group home. Are those people put on the registry? And if not, why not?
Hi, Lori. They can be placed on the registry for abuse findings, not for neglect findings. And the reason for that is the way the statute is written for abuse and neglect. The neglect statute requires somebody to be a parent, guardian, or custodian, and a group home worker does not fit in those definitions, whereas an abuse finding requires somebody to have care, custody, and control, and a group home worker would fit into that. That is something we clarified in the rules as well.
Okay, and the same goes for the foster contractor?
The foster, sorry, I missed that part. The foster, like a foster parent, correct?
Yeah.
Yes. A foster parent can be both because they're considered a custodian per the neglect definition.
Okay.
They fall under that because they're providing parental responsibilities and, have all that control over them in custody.
Right. That seems right. Okay, thanks.
Sure.
Kyle, I just wanted to give an update. I think the latest folks who joined are from the AG's office, but just to give a reminder, we're keeping the line open until noon to receive public comment.
This is Lori Ford again. The letters to parents that will be coming after May 15th, 2026, will those be coming from DCS or the Attorney General's office?
Those will be from DCS.
Okay, thanks. This is Lori Ford again. I'm just wondering, I'm thinking ahead, once this is all said and done, would it be possible for DCS to dedicate a page on their website explaining all of the Central Registry stuff to parents, and also putting an email address on their website for parents who wish to contact the PSRT with new addresses?
Lori, thank you for that. I think that's a great idea. That's something that we'll consider. I think that's something that we might be leaning towards doing.
Yeah, I think that it would just be beneficial for everybody involved here.
Yes.
Okay, thanks. This is Lori Ford again. Before we end, I am just wondering where people can get a copy of the transcript or the recording of this meeting.
Hi, Lori. We were just trying to figure out permissions on that. So we'll figure that out and try to. Yeah, we're going to try to figure that out. Is there a good way to contact you to let you know once we figure that out?
Sure.
Or you can email on rulemaking inbox.
I'll give you my email address right now if that works.
Okay. Yeah.
Okay, it's all lowercase AZDCSOC@gmail.com.
And that was AZDCSover@gmail.com?
OC. AZDCSOC.
Okay, perfect. Thank you.
Yeah, that would be great.
All right, well, the time now is 12 p.m. on October 15th, 2025. At this time, it does not look like there are any other individuals wishing to speak. Thank you for your feedback and engagement on this important topic. Specifically, Lori and Marcus, thanks for your engagement on this. We will continue to accept comments in writing until 5 p.m. today at DCS Rulemaking at azdcs.gov. This concludes our oral proceeding for Title 21, Chapter 1 of Article 5. Thank you all.
Thank you very much.
Thank you, Melissa.
desert where the secrets grow. Names on the list only the shadows know. File stacked high like a tumbleweed roll. Arizona, DCS and Central Registry Data Base.